normal conduct reflects as usual.
All rise if able.
Yes, Mr. Mallew.
My Lord, thank you. My Lord, if I may pick up where I left off with this issue that has been raised by my learned friend as to the question of the relevance of the fact that some of these bills were paid more than 12 months before the time of the application for assessment. I hope I dealt with, albeit briefly, before the lunch and adjournment, the point about the fundamental distinction between payment being an issue which goes to the question, the procedural question of whether an assessment can be ordered, and then the substantive question which may arise on an assessment of whether, because of payment or otherwise, the client is taken to have approved the costs, which of course is where CPR 46.9 comes in, which Mr. Marvin took you to, because that is the rule that deals with the basis of detailed assessment of solicitor client costs, and of course that talks about approval. It doesn't talk about payment, it talks about approval. Now, my Lord, if I can just develop 3 points as to why my learned friend's point in relation to this is a bad point. So the general idea, as I understand it, of the point is that putting aside the procedural question of its relevance to whether an assessment can be ordered, if an assessment is ordered, the net effect, as I understand it, is that on that assessment, what is said is that the solicitor will effectively have a substantive defence to any challenge to the quantum of the bills, and therefore, in practice, because the beneficiary stands in the client's shoes, the client having approved, the beneficiary stands in the client's shoes, the beneficiary is fixed with the consequences of that defence. So 3 points in response to that. The first, of course, is we say that can only be relevant at all if my learned friend's prior point is correct, which is that Tim Martin applies, because what underpins the whole Tim Martin concept is the idea that the beneficiaries' rights to challenge are limited on the basis that they stand in the shoes of the client and are no more extensive than the client. We say, for reasons I'll develop when we come to section 71.3, that that's incorrect and that the rights are not so limited. So if the rights are not so limited, by reference to the challenges the client could have brought, then this point doesn't matter in any event. If we are wrong about that and Tim Martin does apply, we nevertheless say that this point is wrong, and this I don't wish to repeat, but essentially is a development of what I was submitting to the court before the lunch and adjournment, that once you come to the substantive assessment, the issue is about approval or agreement and not mere payment. And I took your lordships to the extract from the Menzies Court of Appeal decision illustrating that payment was an issue to do with the question of whether such an assessment should be ordered, but if ordered, the question of payment did not per se oust the client's rights on that assessment. My Lords, I will come to the Tim Martin case itself inevitably in due course, but I just flag up for these purposes at the moment that when we do, I will seek to highlight a number of short paragraphs where Lord Justice Lloyd refers to agreement and payment of the bill as being relevant to what I will describe as the third limb of the Akin Gump test, which is this idea that over and above special arrangement or out of scope costs, what can the third party do about the more general challenges to costs that the client has incurred? But there are a number of paragraphs where the reference is to agreement and payment, and I say that agreement is essentially used in the same terms as approval. My Lord, just on that, if I can just take your Lordships briefly to the first of, I think it's probably only four authorities, or 4 or 5 authorities.
Just before we do that, when you said my note, but it maybe my note was wrong, you said there were 3 points?
There are 3 points. This is just finishing off the second of those
Fine,
points.
sorry, okay, fine. So I'm still in point 2.
No, my mistake. So this is just concluding point 2.
We like to keep an accurate note in this court. My Lord and I have just exchanged agreement on that. So we're still in point 2, but you'd like to look at some
We're
authorities.
still in point 2, and if I can just take your Lordships briefly to tab 22 of the authorities bundle, the main authorities bundle, which is a decision of this court in a case called Herbert and H.H. Law. We don't need to trouble your Lordships with the facts, but in broad terms it was to do with a solicitor-client assessment of a success fee arising out of a road traffic case. But if I can take your Lordships to page 200, from the judgment of the then Master of the Rolls, if I can pick it up at paragraph 37 at the bottom of the page. So this firstly just deals with a point, but just to give your Lordships the reference, which is accepted by my learned friend, which is that when we are talking about approval in terms of the CPR, we are talking about informed approval in the sense that the approval was given following a full and fair explanation to the client, ... and there's a reference back to a case called McDougall Edgar Estakin. The reference is given there, and that case is also in your Lordships bundle should you wish to turn it up, and their Lordships agree. So approval means properly informed approval, not a mere rubber stamp. And then at paragraph 38 at the top of page 201, we deal with the question of in practice how this operates on a solicitor-client assessment. And if I can pick it up about 4 lines down, just above the B in paragraph 38, where the Master of the Rolls says, we consider that whereas here the client brings proceedings under section 70 subsection 1, so this is just an ordinary solicitor-client assessment, it's for the client to state the point of dispute and grounds for it. If the solicitor wishes to rebut the challenge by relying on the presumptions, so this is the approval or purported approval by the client, the burden lies on the solicitor to show the precondition of the presumption informed approval is satisfied. Once the solicitor's adduced evidence to show the client gave informed consent, the evidential burden moves to the client to show why, as a result of that, there was no consent or it was not informed consent, and the overall burden of showing informed consent remains on the solicitor. So it is potentially a detailed process as part of the assessment as to whether or not approval was given and the quality of that approval, if it is to satisfy as a defence by the solicitor in whole or part to challenges. And of course, just in passing, one point we make here, it's important to bear in mind when we come in particular to the second limb of this appeal, just what the cost judge here was doing. The cost judge here wasn't determining the assessment. All the cost judge here was determining whether there should be an assessment.
Yeah.
Issues as to whether in due course the solicitor will be able to establish approval in light of whatever challenges might be made in the points of dispute, in light of whatever is shown in the detailed breakdown of costs that the solicitor will produce as a first stage in that assessment, are all matters which will be dealt with at the substantive hearing of the assessment. All the cost judge did was form a view that there were essentially arguable points on those matters. So to conclude our second point, therefore, we say even if Tim Martin does apply, it is wrong because it seeks to elevate the question of payment above the question of whether there has been approval, and it's nothing to do with timings. Timings is the procedural issue. On an assessment that is all past the assessment, the question is approval or not. The third point, and I'm hesitant to take a procedural point before this court, when in any event we say we can answer the point and have done substantively, is that we say that this is not, in fact, a point properly taken on this appeal. And in saying that, I would invite your lordships just briefly to turn up, first of all, the grounds of appeal, which are page 15 of the appeal bundle.
Yeah.
And just on page 15, the grounds are mercifully and admirably short. But if we come to ground 2, ground 1 is obviously simply wrong to not apply Tim Martin. If we come to ground 2, we can see what is said, that the judge wrongly concluded that if Tim Martin did apply, the blue pencil approach would permit of potential adjustments. And it goes on, and then it specifies, in particular, he wrongly concluded the court would be able to adjust hourly rates, disallow fees, etc., etc. There is nothing, firstly, in ground 2 which says, and the judge was wrong not to find that there was an absolute bar in relation to most of these bills because the points were not open, because the executor client himself was more than 12 months past the time that he had paid those bills. And just to develop that point very briefly, if I can invite your lordship's attention to paragraphs 15 to 17 of the skeleton arguments, which are on page 21 of that bundle.
Appellants.
Appellant's skeleton argument. Lord, yes, thank you. Page 21 of the bundle. So this is where the argument is set out in respect of the effect of the presumptions in 4619. So just following this through, I'll just pick up that at paragraph 16, at least in the skeleton argument, the appellant appeared to acknowledge that the issue here was this question that I've addressed, which is approval rather than payment, and they go on to refer to paid and agreed the solicitor's bill as being the point that they rely on. But the more fundamental point I take is that there is nowhere in the skeleton argument, unless I have missed it, where it is said that these points were not open to my client at all because of the point that they were not open to the executor, because of the procedural point that the executor would have been required to have made an application before the time when the beneficiary made the application. It's a very cheap point that the point may not be in there because it may not have been thought to be a good one at the time, but the fundamental point is it isn't in there. We rely more fundamentally on our substantive response to the point, but we do say it's actually not a point properly taken on this appeal. Finally, my lords, in this regard, can I just come to a point as to why, in fact, this is of some relevance when we do come back to, if we do come back to round 2 of the appeal. And this is because of something that the judge said in his judgment, which is page 88 of your lordship's main appeal bundle. And apologies for jumping about slightly, but I'm trying to deal with this question of approval and payment relatively comprehensively. We'll look at it briefly again when we come back to Tim Martin, but in terms of these points. So this is at page 88, and I'm going to start at paragraph 77. This is when the judge is dealing with the question of if Tim Martin applied, would an assessment serve any useful purpose? And your lordships have that heading 2 pages earlier in the bundle. So paragraph 77, what the judge is dealing with, as your lordships can see from paragraph 76, is the question of whether the challenge is of a type, as he puts it, that's open to the person chargeable with the bill to take. And I'm not wedded to the term type at all, but the more fundamental point is he then expresses a concern as to how much the points that have been taken would assist the defendant solicitor in any event. He firstly deals with the point about payment, and at the very end of page 88 notes payment is only effective for these purposes if there's been a settlement of account. Now just pausing there, that's the Menzies point. He's wrong about that, no criticism of him, because at the time he was right about it because there was a High Court judgment telling him he was right about it, but the Court of Appeal said that's wrong. So there doesn't need to be a settlement of account for payment. But then as we go on, he notes, but agreement to deduction, so which is the sort of payment that the Court of Appeal does talk about in Menzies, is not agreement to the sums claimed in the bill. And that, of course, is the point that the Court of Appeal does make in Menzies. He notes that the solicitors say in a letter dated the 20th of August that the final bill has been agreed with the executor, taken on its face, that might well indicate agreement to the final bill, but it's not clear whether all the other bills have been agreed in the amounts claimed, noting the distinction, which is a distinction maintained by the Court of Appeal, between approval for payment and agreement to the bill. So in other words, payment and agreement to the bill are two separate things. Agreement is synonymous with approval. And the point he is making there is for everything that my learned friends Junior was saying below about the restrictions that would apply if Akin Gump applied, and of course we say it doesn't. But the point he was making there, which we'll come to in a moment, is even if they were right about those restrictions, the key third limb of Akin Gump only applies where the client can't take the point because they've approved the bill. And the judge is saying here, I'm not satisfied at the moment that it can be said clearly that the client has approved the bill. That's an issue that he doesn't reach a final decision on it because that's an issue that will be looked at in the substantive assessment that he's ordered. But there's no challenge in this appeal. No part of this appeal says the judge was wrong because he should have found that there was approval as well as payment. There's no challenge to say that the judge was not entitled to say he wasn't satisfied that there had been approval. And therefore, in our respectful submission, whatever else is said about limb 2 of this appeal, it falls because the judge was perfectly entitled to say it may be open to the client on this assessment, to the exec, get it right the third time, hopefully. It may be open to the beneficiary on this assessment to say that there has been no approval of the bill by the executor, and therefore all challenges to reasonableness, even if Akin Gump applies, even if Tim Martin applies, all the usual challenges to reasonableness may be open to the beneficiary. And if that's right, and whatever else he said about limb 2, it would have been wholly wrong for the judge to shut out the assessment, and all he was doing at that point was ordering an assessment in principle. It would have been wholly wrong for the judge to shut out an assessment on the basis that it is said he must have been satisfied at that point, that the assessment could serve no purpose whatsoever.
Can I see if I've got that right? There's no challenge on the basis that he should have found that there had been approval.
Correct.
The judge was entitled to say it may be open to the beneficiary, so there's been no approval of the bill. If that is right, all what I'm going to call Section 70 challenges are open.
Lord, yes. Your Lordship has put it in 3 short sentences, what I put in several paragraphs, but yes, my Lord.
Yeah, well, I can't type as quickly as you can see.
My Lord, yes. And just to finish that point off, it comes back to that section I took your Lordships to in the Herbert case as to how these things will work on assessment. There'll be a detailed breakdown. My client will set out the challenges. The response may be that there has been approval. The judge on assessment will test the quality of that approval if it is asserted as a defence by the solicitors. We're not at that point yet, and it wasn't open to the judge. It wasn't open to the judge is my submission, let alone can it be said he was bound to say that he could rule that possibility out.
When you looked at that paragraph in Herbert, this shifting, we were told earlier, and I don't think it's in dispute, that the presumptions in 46.93 are rebuttable.
Lord,
So
yes.
that even if you get to a stage of showing that the quantum was approved and the approval was full and fair and informed and so on, so the presumption applies, there is, at least in theory, a further stage at which it's open to the client to rebut the presumption.
My Lord, your Lordship has identified a point that I was going to come to, but absolutely the presumptions are rebuttable. Now, in an ordinary solicitor-client situation, it may be relatively difficult for the client to rebut that.
Well, that was going to be my question. What sort of, once you've approved your solicitor's bill, what material can you rely on to rebut it?
Well, Lord, I can see that it would be difficult in practical terms, but the question is, in this context, in the section 71.3 context, would there be circumstances in which the presumption could be rebutted? Because it seems in my submission, it would be an all the circumstances test. In all the circumstances, can the presumption be rebutted? And one of those circumstances, of course, is that the approval may have been given by an executor in circumstances where the solicitor knew he was acting as executor, where the solicitor knew that the sums which the executor was agreeing to pay were sums that he bore no ostensible personal liability for, but which would be met out of trust funds. And it seems to me that is a circumstance which may make it materially more likely in that situation that even if the executor has given informed approval, the court may nevertheless say, well, looking at the detail of these figures, they still seem unreasonable to me, and I'm not satisfied in the context of a solicitor knowing that they're acting for a fiduciary on behalf of a trust or estate, that that approval is sufficient to rebut my concerns as to the reasonableness of these items.
Yes. Okay, thank you.
Lord, so that was an entry into maybe a slightly out of turn point, but the point about payment and approval and the fundamental difference. Can I return then to ground one of this appeal, which really is is there a difference between section 71.3 and section 71.1, and does Akin Gump apply? My lords, I'll try and deal with these points fairly shortly, but if we can start just with the obvious point, if I may, which is a point your lordships are very well aware of, but is the wording of the sections. And if I can just invite your lordships firstly to turn up tab 2 of the authorities bundle, and starting at page 5, which I'm going to have to put my glasses on, the type is very small. Sorry, apologies, page 6. So these are the predecessor sections to section 71. Section 38, which is the predecessor to section 71.1, and then over the page, section 39, which is the predecessor to section 71, subsection 3. And your lordships, I'm sure already have these points, whether it favours me or not. But the short point is the fundamental difference between the wording here. And I'll just identify one part here, which is if we pick it up 4 lines down in the first part of section 38, which is where what is being dealt with in the context of a third party, just a general third party, is the ability to make such application for a reference for taxation as the party chargeable therewith might himself make, and the same reference and order shall be made thereupon, and the same course pursued in all respects as if the application was made by the party so chargeable with the bill. Now I'll just flag up that the wording, the same course pursued in all respects, does not feature in section 71, subsection 1. And the reason I flag it up is because it's a point specifically addressed by Lord Justice Lloyd in the Tim Martin case. The reason I further flag it up is because, of course, that wording really undermines Mr. Marvin's argument that all section 38 can assist the court with is the question of what order to make on whether to order an assessment, as opposed to the course the assessment will take once the assessment is ordered. And we will come to it, but my Lord Justice Lloyd in the Tim Martin case expressly rejects an argument by the appellant in that case that the removal of those words mean that the ambit of section 71.1 is narrower than section 38, and therefore that the scope of what a third party can do is now broader than it used to be under section 38. Because really, as we will come to see, what the courts have done is taken the wording from section 38 and said that wording tells us that the remedy available to the third party is limited. Not simply that the order for assessment, but the remedy available on the assessment to the third party is limited. And that is what underpins the Tim Martin case. And the suggestion that the removal of the words "and the same course pursued in all respects" makes a difference is expressly rejected in the Tim Martin case. So, my lords, we can see that wording, and that wording really could not be any clearer, that the third party only stands in the shoes of the client and is limited to what the client could have done. We can take that wording and we can then turn over the page. And we can see, I'll put it no different than the very much more open textured wording of section 39. So again, I won't go all the way through it, but the starting point is what we're dealing with here is the question of trustees, executors or administrators, so a specific category of cases where people are acting in a specific fiduciary role and where the usual expectation will be that the funds out of which any bill that they incur for solicitors' charges will be met not by them personally, but out of the trust funds. We can then see, if we come to the third line, that the application is then by the person interested in the property, out of which the executor administrator may have paid or be entitled to pay such bills. So again, the starting premise is again that the funds out of which the bill is going to be paid are not the trustee or executor's own, but those of the trust fund. Although I don't put too much emphasis on it, I note that the wording used is that the trustee, executor or administrator may have paid or be entitled to pay. So the underpinning assumption appears to be that this is a situation where the executor is doing nothing improper. They've been presented with a bill in their role as executor. They're entitled to be paid it out of the trust funds. But in that situation, the section goes on to give the beneficiaries a freestanding right to challenge that bill as against the solicitor. And so we can go on. The next line down, then they can make an order for the bill, an application for the bill to be taxed and settled with such directions and subject to such conditions as a judge shall think fit. So conditions are things such as whether there's any question of payments or anything of that kind. But then it goes on, and to make such order as the judge shall think fit for the payment of what may be found due and the cost of such reference to or by such attorney or solicitor, or the executor, administrator or assignee of such attorney or solicitor, by or to the party making such application. And just to pause there, this wording is essentially carried forward to section 71 subsection 3. And what it is doing there, in contrast to the concern that Lord Justice Lloyd had in the Tim Martin case about there's a real problem here. We've got a third party challenging the solicitor's bill where the client has agreed and paid that bill, and the cost judge Campbell's ordered the solicitor to pay money back to that third party. What section 71(3) does is basically give the court a very broad power to say, if you do this assessment, you have a broad power to decide in all the circumstances who should pay what to who. Should it be the solicitor who's paying money back? If it is, should it be paid back to the executor, or should it be paid directly to the beneficiaries? Should it be the executor? And of course, you could have a situation where the beneficiary brings the assessment against the solicitor and the court thinks it's appropriate to give the executor the opportunity to make representations or be joined. But the court has a very broad power to look at how to resolve the outcome of any such assessment, consistent with the idea of this very broad exercise whereby the beneficiary is entitled to take points regardless of whether or not the executor client has taken them or indeed could take them. And that section ends with a reference to when exercising the discretion, the judge may take into consideration the extent and nature of the interest of the party making the application. So it's their interests that are one of the factors that the court may take into account. And then you see again in the next paragraph, provided always that where any money shall be so directed to be paid, it shall be lawful for the judge, if it shall think fit, to order the same or any part thereof, again to be paid to the trustee, executor or administrator so chargeable with the bill instead of being paid to the party making such application. So very broad powers to essentially allow the court to do whatever it thinks appropriate to resolve the outcome of the assessment. So that's what it says. What it doesn't say is anything of what we've seen in section 38. Anything of the order being restricted to such order as the client would have been entitled to, anything about the course of the proceedings following the same course in all respects as if it had been an application by the party so chargeable. And my Lord's, just pausing there, whilst I take on board the point raised by my Lord Justice Nugee earlier, which is that under the present equivalent of these, query whether a beneficiary could be a third party under the different section. I acknowledge all of that, but what could, of course, happen very simply is, bearing in mind that this is legislation that's been carried for, rewritten and consolidated, if there was no difference between these two sections, why do we still have two sections? Why does section 71(1) not simply say where any third party, brackets including any beneficiary of an estate, brackets, wishes to challenge the bill, they can do so, but they can only have such order as the client could have had? Why does it continue to exist? And that, in my submission, is a point that really the appellant has no answer to. My Lords, I ought to take you just briefly to section 71 itself, which is page 12. So the equivalent, of course, so we've had two sections now consolidated into one. So the equivalent of section 38 is now section 71(1). And you will see at the end of section 71(1) essentially the same words, apart from those words in the same respect. It shall follow the same course in the same respect. But I've addressed that. You then have section 71(3), and again, in broad terms, following the wording of section 39, and again at 71(3)(b, you will see that broad power, which doesn't exist in section 71(1), but is in section 71(3), for the court at the conclusion of the assessment to essentially decide who should be paying what to whom, including any of the relevant potential parties. So those are the sections. My Lords, can we then come to the question, the core question of, well, don't they in fact just mean the same thing, and therefore isn't this court, and indeed the court below, bound by Akin Gump to reach that conclusion? So, my Lords, if we can come to Akin Gump, which should, I hope, be behind tab 17 of your bundle.
Notwithstanding the odd slip, we've been calling this Tim Martin.
My Lord, yes, it's my fault. I have it all from my
Suddenly,
notes.
I thought we were going to a different case. I was excited briefly,
My Lord,
but that it is. We'll call it Tim Martin if that's all right.
well, my Lord, I'll take you to a different case in a moment. Whether the excitement will continue when we come to that different case, we'll see at the time. But it's entirely my fault, because I've throughout been referring to this as Akin Gump, and it's a mental block that I'm finding it hard to shift, but I'll do my best. So, my Lords, coming then to Tim Martin. So the first point is that the scope of what is an issue in Tim Martin is, of course, delineated by the nature of that case. And that case was a straightforward mortgagor mortgagee case. There was no issue in that case that this was a section 71(1) case. Just going through the judgment and picking up points so that I don't have to come back to them. If I can pick the judgment up at page 105, letter G, just harking back to a point I made a short while ago, and it may continue to be relevant. At letter G, you will see what the defendant's, so the solicitor's final bill was, and then you will note there the bank approved the bill and paid it in full. Going back to that distinction between approvement and payment, as far as I'm aware, and there's nothing in the judgment that suggests otherwise, there was no issue in this judgment, in this case, as to whether that was or was not informed approval. It was accepted and taken as read throughout that the approval of the bank was approval in the sense meant by CPR 46.9 and by the authorities that we've looked at. So this was a case where there was both approval and payment by the client. My Lords, if we can pick it up then at starting at page 109, paragraph 19, this is where Lord Justice Lloyd embarks, for very understandable reasons, on a journey through the cases dealing with the earlier forms of the relevant litigation. And it's important to note where he starts at paragraph 19. The provisions of sections 70 and 71 go back to sections 37 and 38 of the Solicitors Act, not section 39, of course, which is the origin of section 71, subsection 3. You will note, or I invite your lordships to note at letter H, where his lordship identifies section 38, and then the point about provided the same reference and order shall be made thereupon, and the same course pursued in all respects. And so that is the starting premise. He goes on, just in passing, just for your lordship's benefit, page 110, para 22. The point raised by my Lord Justice Nugee. Lord Justice Lloyd accepts, of course, that the presumptions in 48.82, the predecessor to 46.9, are rebuttable. He also makes the point that the unusual cost presumption appears to take precedence over the other presumptions. And then he goes on, subject to that, however, if the client has expressly or impliedly approved of the incurring of costs for which the bill is rendered, and their amount, there seems to be no scope for contending that the costs ought to be disallowed as between solicitor and client. And that is an important point, because again, it makes the point that what Lord Justice Lloyd is coming back to later is dealing with a situation where he's looking not just at payment, but at approval, which would prevent the client, in this case, from mounting any quantum challenge to the bill. I'm going to pick the judgment up again at page 112, where I can just invite your lordships to briefly look at paragraph 33. You were shown a succession of cases decided under the 1843 Act since, subject to one contention for the claimant, and that's the contention about the change in the wording, the in all respects wording. The legislation is in substance the same. The decisions of the Court of Appeal on section 38 of the 1843 Act bind us in relation to section 71. It is in my submission difficult to see how that can be said to be the position in respect of the section 39, which has become section 71.3. The reason for the wording is, of course, obvious, that Lord Justice Lloyd was only taxed with the question of the construction of section 71.1 and was not addressed, it would appear, at all on whether there was any material in the difference between that and section 71.3. Thereon, the court goes on to deal with cases. We can pick it up. It's mentioned in most of the paragraphs. Paragraph 34 refers to section 37 and 38. Paragraph 35 refers to 38. It goes on. I'll only stop at page 114, paragraph 40, because of the mention of Re Brown. I'm going to come to Re Brown itself. But this is, of course, of some relevance, because his lordship appears to accept that Master of the Rolls in Re Brown was dealing with a taxation under section 38, and that appears to be what the judgment says. He notes, I think what he's really saying in the parentheses is it looks as though that probably should have been a taxation under section 39, but nothing seems to turn on the difference. And of course, the important point is nobody tells him that anything might turn on the difference.
Say that again.
Nobody tells him that anything might turn on the difference.
Yeah.
Which is not a criticism of the council in that case, because they weren't interested in whether anything turned on the difference. I just pick up at page 115, paragraph 42. But in closing off the question of Re Brown, his lordship notes that the report from Re Brown is one of those mercifully short Victorian reports, does not disclose what order had been made, but since the trustee was not a party to accept the taxation, there cannot have been an order against him. Presumably, therefore, the order was that the solicitor should refund money to the trust fund or to the beneficiaries directly. Just pausing there, we don't know what the order was, but what we do know was that under Section 39, which Lord Justice Lloyd was not taken to, in contrast to Section 38, the court had the full power to make orders against whoever it considered appropriate, including the executor. So we don't know. It could have been that there was an order against the trustee in that case, or it could have been that the order was as Lord Justice Lloyd surmises, but we don't know. But what we do know is that the court had the power to do any of that. And he does know that it's more promising for third parties and for the claimant in the case that's before him. In other words, Brown may offer them some support because it shows a different attitude from that adopted in the earlier cases. All of those other earlier cases are, of course, pure Section 38 cases.
Oh.
Look, Brown is the only one which seems to blur the lines in some way, and it's perhaps no coincidence that the one case that seems to touch on the interests of beneficiaries is the one where those lines appear to be blurred.
Mr. Marden accepted that both before and after Brown, the cases that are analysed here were all Section 38 cases. Is that your understanding
That is
too?
my understanding also, Lord, yes.
Yeah.
Brown is the only one that touches on Section 39, possibly.
Yeah.
There is one other case which I'll take your lordships to, which touches on the position pre-Section 38 and 39. Whether it assists your lordships...
Pre-Section 38.
Pre-Section 38 and 39. I don't want to go too far back.
It's
Again,
quite unusual to be going back to the 1860s. Before that, I'm bound to say I'm rather hoping that we don't need to delve. But
Well,
I'll leave it to you.
My lord, it is, again, thankfully, a short report. It's 1817 is as far back as I anticipate going. Whether it assists will, I suspect, become apparent relatively quickly.
He was Prime Minister in 1817.
Right.
Well done.
I don't know. I was going to say, obviously, my Lord Justice Stuart-Smith was a thrusting young junior in the...
I was trying to remember the Duke of Wellington was Prime Minister. I can't remember.
So anyway, 42, we have your submissions on that. Different attitude. You say, well, there may be an explanation for that because Brown is the potentially generator Section 39 case. Yeah.
So, the Lord, if I can then pick it up, paragraph 50, 119. Lord Justice Lloyd is summarising a case called Re-Gray, and he notes that the first of the paragraphs, we don't need to go to the citation unless it insists, states the principle by then reasonably well established that the scope of taxation under Section 38 was limited to the solicitor's bill to the client in relation to the matters for which the third party was liable, and he goes on to elaborate and develop essentially the point that's made in those cases by reference to Section 38, that the third party is standing in the shoes of the client. So, Lord, you'll be
So
pleased.
where are you reading from? One.
Sorry, Lord. It's essentially I've sort of paraphrased the entirety of paragraph 50.
Oh, right. Fine.
It's simply making the point that when analysing these cases and deriving from the proposition that the third party is limited to challenges that the client could have brought.
Yeah.
It is done firstly by reference to the limits imposed by Section 38, and secondly, the cases that are analysed are analysing Section 38, as we've already established. So, my lord, can I come on then to something perhaps of more moment, which is page 125.
Mm-hmm.
This is where, your lordships will recall, we saw that Lord Justice Lloyd said that apart from one change in the wording, it was agreed that the wording was the same in all respects in Section 71 as in the earlier sections. And this is where he deals with the argument about the wording. And so that wording, as we see at paragraph 68, was the same reference and order and the same course pursued in all respects. Whereas the latter acts use, the court may make the same order as if it might have made if the application had been made by the client. He deals with the question of the omission of the word reference. He says that's just a change in the language. But then, just between C and D, he notes that Mr. Safi argued that the later language gave the court greater scope than had the 1843 Act on a third-party assessment, prescribing that the court could make the same kind of order, but not necessarily the identical order, and he pointed to the omission of the words in all respects in the later acts. And that is rejected at 69 The purpose of the provision for third-party assessment is the same as it was under the 1843 Act. It is to allow for an assessment between solicitor and client in a case where a third party is liable to pay those costs and where there hasn't normally been an assessment under Section 70. Differences in statutory language are purely presentational. They do not change the substance of what the court can do under the section. And then he goes on to note, apart from the fact an assessment under Section 71 must be limited to the cost which a third party is liable to pay, which may be more restricted in scope. The certificate resulting from an assessment, so the outcome of the assessment under Section 71, must be for the same amount as would have been the result of an assessment under Section 70. And he is deriving that from the authorities on Section 38 and from his rejection of the argument that the change in wording between Section 38 and Section 71(1) means that the court is freer to arrive at a different outcome.
So, I'm sorry to be so slow, but the submission that you make at the end of that is that this passage in 69, which is dependent upon the language of the statute, and reaches the conclusion that the applicant stands in the shoes of the client, is your answer to Mr. Marvin's submission that it's only dealing with who can make an application.
My Lord, yes, we say it falsifies that argument.
Yeah.
I haven't taken your lordship through, your lordships will, I'm sure, be grateful, through all of the Victorian cases on Section 38, but if necessary to do so, if we look at those cases, your lordships will see that the prism through which this question of the limitation on the outcome of the assessment is looked at is because of the restrictions in the wording in Section 38.
Thank you. Could you just hold on a second? Thank you.
So, my lords, just pausing there, because this then involves moving on to a separate limb of the argument. To summarise our position in relation to Tim Martin, we say firstly that there can be no question that Lord Justice Lloyd was intending to, or did, give any judgment on the effect of Section 71(3). It's not what he was asked to do, it's not what he purported to be doing, and it would be unfair of him to treat his judgment as doing so, because he wasn't given the assistance he would want if he was to give such a judgment. The way the appellants put it in their skeleton argument was that they accepted that Tim Martin was technically distinguishable. Well, it's distinguishable or it's not, and it's distinguishable. And it's distinguishable firstly on its facts, but of course it's distinguishable much more importantly because it's dealing with a different statutory provision. We say it cannot be any part of the ratio of Tim Martin to seek to address Section 71, subsection 3. We also say in summary that it is important to understand what underpins Tim Martin, which is the analysis that Section 38, through the authorities, is what has led the court to conclude that there are limitations on the remedy, the effective remedy, not merely the procedure that is open to a third party.
And so you say that's why Brown appears to be an outlier
Indeed, so.
if one tries to shoehorn it into Section 38.
Well, Brown is a bit of a difficult case to approach from any angle, not least because it's not clear what it's purporting to deal with. And it's also, we'll come to Brown very briefly in a moment, but it would appear that in some ways, at least, what the Master of the Rolls was doing in Brown was essentially testing a proposition put to him by the advocate and saying, well, even if you're right about this, it's not going to get you anywhere because even if we're under Section 38, these are items that the cost judge was entitled to disallow. And if that's right, it didn't matter whether it was Section 38 or 39. 39 would have given the client, the beneficiary, greater rights to challenge. But if the response to the appeal was, well, it doesn't matter because even under Section 38, these are items that could have been disallowed. That may explain why there's a certain lack of precision in the judgment as to whether the court's dealing with 38 or 39. It didn't really matter.
So on that reading, you say what? That Brown, whether it's under 38 or 39, the point that Lord Romilly makes would apply in any event.
Lord, yes. So what Lord Romilly...
I think it's been called a special arrangement.
Yes. I mean, it's debatable on the facts whether the court costs are what might be called special arrangement costs or out of scope costs. So ones that the executor could never charge, or ones the executor could only charge if there'd been a
whatever
special
label
arrangement.
you
But
put
whichever they were points open on Section 38 as well as Section 39.
Yeah.
Section 39 would have been broader, but if the answer to the appeal was, well, even under Section 38, these points would have been deductible, it doesn't really matter for Brown's purposes whether it was Section 38 or 39. What may be relevant from Brown, but I put it no higher than this as sort of tangentially relevant, is the point Lord Justice Lloyd made that we saw earlier in this judgment, that it appears to indicate at least some sort of different general approach by the court, and what may underpin that is because the court appreciated it was dealing with a beneficiary, but on the actual case it didn't matter, it didn't make any difference. So, Lord, that really is in substance our case as to why we say Tim Martin doesn't apply, subject to one further judgment I'm going to come to. The second part of Tim Martin deals with the question of what's the effect if it does apply. Now, entirely in your Lordship's hands, I'm happy to stay in Tim Martin and deal with that second limb now, or to deal with the other case on the first point and then come back to Tim Martin on the second limb. I don't want...
Speaking for myself, and if it's no inconvenience to you, and if my lords don't disagree, could you carry on with dealing with the first point and then come back to Tim Martin on the second point?
Of course, my Lord.
If that's not inconvenient.
Not at all.
It helps my note taking.
I'll park Tim Martin for a moment and then just deal with the remaining two cases in relation to the first point. I just note in passing that your Lordships weren't taken to it. Your Lordships have an extract from Lewin on Trusts. I don't invite you to turn it up. It's page 312 in the authorities bundle. If read in the cold light of day, it would be said to be dead against me because it suggests that Akin Gump does apply. But if we look, we don't need to, but it's a very short reference. It relies entirely on saying Akin Gump deals with both Section 71 and Section 73. So if this appeal is right, then the reference in Lewin is simply going to need updating.
Just before you leave Tim Martin on this point, it's fair to say, is it not, that Lord Justice Lloyd assumes that what he's saying is applicable to the case of a trustee and a beneficiary?
He does mention that, as he gives a number of examples of other circumstances. He does it at the start when I think it's paragraph 2.
Paragraph 2, and he does it again at 71.
He does at the end when he's talking about the accounts as well. So he does, and of
You
course,
just say that nobody told him otherwise.
Lord, exactly so. I'm afraid that appears to be. This is no criticism of those there or anybody involved. There were some very experienced advocates in front of him, but it wasn't an issue for them. It simply wasn't an issue for them.
And it wouldn't have done them any good to distinguish Section 39. It wouldn't have assisted either
Well, I
side.
suspect it would have muddied the waters, but it certainly, I mean, arguably, from Mr. Safi's point of view, as the person on behalf of the third party seeking to expand the scope of the challenge, it certainly wouldn't have, it seems to me, assisted him, because the obvious
It would
argument...
just point up a contrast between the two sections.
He would have run into an argument saying, well, doesn't that make the point? Doesn't section, if you're highlighting Section 71.3, doesn't that just emphasise what Section 71 could say, but doesn't? So that he would have run into that problem. Mr. Bacon, the highly experienced counsel, of course, could have taken the point. It doesn't appear that he did. Why he didn't is a matter for him. It may be that with the rub of the green as it was going before the court, he simply didn't feel it necessary to do so. But
on the face of it, if anybody wanted to distinguish between the two, it would have been Mr. Bacon.
It would have been likely to be Mr. Bacon.
It might have provided some assistance.
Yes.
On your analysis of what Tim Martin means.
Yes, it seems to me that's the case. But what I think we can say, and I think in essence this was accepted by my learned friends, it simply doesn't appear that Lord Justice Lloyd was dressed on it and these differences. my lord, I do take the point that it could be Lord Justice Lloyd with his huge experience. If he thought there was a point there, it may be that he could have raised it himself. And I have to acknowledge that he didn't. But I do query how far that takes us in the grand scheme of things, when before this court now the point has been fully developed and argued, whereas at most it would have been an obiter observation by his lordship during the course of that case. So, Lord, I was going back in time, if I can put it that way. Re Brown, my lords, unless it will assist, I don't particularly want to delay your lordships by going back to Re Brown in any detail. We've touched on it already.
You've touched on it, haven't you?
If there are any issues in relation to Re Brown your lordships have for me, I'm happy to seek to address them, but I don't want to take up your lordship's time.
Well, your primary submission is the one you just made, isn't it? That it could be said that it doesn't matter whether it's section 38 or 39, because Lord Romilly was saying, well, whichever it is, this point would still apply.
Well, Lord, yes, and I accept that involves a degree of reading between the lines on my part, but these short judgments from the Victorian era sometimes lend themselves to having to be read between the lines slightly.
Well, I'm sorry, I do find Re Brown quite difficult, as you said, and I think I would be assisted another look at it.
Lord, of course.
What I find difficult is that the first part of the judgment is relatively clear, which is the one that says, well, when you're dealing with a trustee, if it's not really needed for the administration of the trust, it's the duty of a solicitor to say, well, I'll do it if you ask me to, but you can't pay for it out of the fund. And that point, it seems to me, can be taken on an assessment under section 71(3). And that indeed, that's whether Tim Martin applies or doesn't apply, because Lord Justice Lloyd says exactly the same thing. If it's not within what you call out of scope, it's fine. What I've not found so easy is what Master Earls is saying in his final paragraph, where he talks about quantum and courtiers and so on. Is he assimilating the case of 10 or 12 interviews to the same out of scope type objection, or is that a different objection that's being taken?
My Lord, I wish I could give you a clear answer to that. I can put it no higher than this, that it appears that is what he is doing. If that is what he was doing, it might be said in any event that was obiter, because it would appear, and I'm cautious with all of this, from the head note, that what had been taken out of the bill were essentially what we might call blue pencil items, where the whole item had been taken out. So any question of quantum as opposed to courtiers would perhaps have been obiter in any event, but that does appear to be what he's doing. And I appreciate it's not very helpful, but I can put it no higher than that.
Okay. Thank you.
My Lord, since we're there, of course, I would just highlight what is said at the start of the Master of the Rolls judgment on page 27 of the bundle. Because we do say this is material. It has limited materiality in terms of the outcome of a particular case before him, because this point, as I say, is one that could be taken by a beneficiary or indeed by a general third party, this out of scope point. But the point that is made about 5 lines down at the start of the judgment is the reference to if a person being a trustee chooses to employ a solicitor for the purposes of conducting the affairs of the trust, which of course the solicitor is well aware of. There is a distinction between his employing that same solicitor for exactly the same purpose with regard to which he is not a trustee. And we say that's an important point, and we'll come to see this in another context, because from the solicitor's perspective as being the target of the assessment, of course, the material difference between section 71 and section 71, section 71(1) and section 71(3) is the point that the solicitor under section 71(3) is being instructed in circumstances where they are or should be aware that they are being instructed by somebody who owes a fiduciary duty to another party, the estate, and that their fees are likely to be paid out of that estate. And we say in that context it is no surprise that those who ultimately will bear the burden of that should have a freestanding right to challenge the reasonableness of that solicitor's fees.
could say that with some of the Section 38 cases. If you're acting for a mortgagee selling the mortgaged property, you know that the mortgagee is going to take their costs of sale out of the proceeds of sale. If you're acting for a landlord who you're drafting a lease for a tenant and there's a covenant in the lease for the tenant to pay the landlord's charges, you know that the landlord is going to pass on his bill to the tenant. So you can't draw a sharp distinction between.
Well, my lord, I accept there is a potential for some cases under Section 71(1) to engage that proposition. But of course, it's not me that is drawing the sharp distinction. What the sharp distinction is drawn by the statute, with a different provision for those who are trustees or executors and the rights of beneficiaries under those trusts or estates, as opposed to general third parties. Now, we all know that statutes sometimes can be a blunt instrument, but it's the statute that draws that dividing line and indicates what in my submission is plainly a broader remedy for those in that position than those in the general position of third parties, where I accept, my lord, in some circumstances there may be a very close analogy, but in others there wouldn't be. So, my lord, I'm not going to delay further on Re Brown. I am, however, going to tempt fate by inviting your lordship's attention to one other case, which is tab 5, and that's a case called Hazard and Lane. And this is a case which predates the 1843 Act. And so I appreciate your lordships may not be as familiar with this case, but it's a slightly odd case. But what happened in broad terms is that there was an estate. There were two executors. One of the executors had essentially been the active executor, one the passive. And as we see from the head note at the line, there were bills rendered by solicitors in relation to the work they had done on the acting executor's instructions, and those bills were paid by the acting executor. There was then a delay in settling the executorship accounts, which were in due course settled and indeed approved by the beneficiaries. But then the beneficiaries, I don't think we need to worry about one of them having been a married woman, but then the beneficiaries in fact go further and execute a complete release to the solicitors.
Executors.
Sorry, to the executors, apologies. To the executors, but then what they do, having taken further advice, is they seek to challenge those costs that the solicitor had incurred, which had been paid, and it would appear in essence approved by the active executor, and they seek a taxation, as it was known in those days, of those costs. To do so, because Section 39 didn't exist in those days, they had to do so using the name of the other executor, the passive executor. In terms of the nature of the challenges they wanted to bring, if I can invite your lordship's attention to page 17. Unfortunately, there are no letters on this, but just over a third of the way, between a third and a half of the way down, there's a semicolon and then a sentence, a part of a sentence beginning, but shortly afterwards. So this is after the beneficiaries have signed the estate accounts, but shortly afterwards, on delivering the bills to his solicitor, so that's the beneficiary's personal solicitor, he was informed that they contained many overcharges and other improper charges, upon which he resolved to apply to have the same taxed. And then there was an affidavit. And there's reference to the fact it was necessary for the application to be made in the names of one of the executors. So the issue was overcharges and improper charges in the bill. We can then come over the page. And so the judgment is, in fact, two paragraphs, just two paragraphs. One is not, I think, strictly speaking, part of the judgment. It appears to be sort of a summary. And then the paragraph heading starting August 25th appears to be the judgment. Just starting with the first paragraph, the Lord Chancellor considered. Extremely important case by reference to general principles. application by one or two trustees executors hardly acted without the consent of these acting co-executor for taxation of the solicitor's bills and costs which have long since been paid after a full settlement of accounts, supported by allegations of gross overcharges. And then one of the questions is whether the solicitor shall be permitted under such circumstances to avail himself of the payment by the trustees and subsequent acquiescence. In those days there was no CPR 46.9 type test of approval, or otherwise to say that by reason of length of time he's deprived of the means which he otherwise might have had of defending the propriety of the charges. And then
Is that a separate late cheese point or something?
it appears to be a delay, a late cheese or delay point. And then when we come to the judgment, his lordship pronounced judgment in the next paragraph in the case. He recapitulated the facts. He puts aside the question of the release. I don't think we need to worry about that. And then if we pick it up, and the part beginning, and on the other points in the case, the next line, his lordship held that a solicitor cannot be allowed to interpose the payment of his bill of costs by a person in the situation of a trustee between himself and the parties, beneficiaries, for whom he was at that time aware the person who paid him was no more than a trustee, as here an executor, and that the beneficiaries whose funds were to bear the whole expenses of the suit had a right to make use of the name of their trustees and executors to obtain a taxation of the bill. Although these trustees and executors would be entitled to retain or be paid any money which they had expended, yet the taxation of a solicitor's bill could operate no injury to them, as a solicitor could have no right to demand against them more than would be allowed on taxation. So what is happening there, which is entirely contrary to Mr. Marvin's submissions, this isn't saying your issue is with the executors, go against the executors. What it's saying is, albeit you've got to use the name of one of the executors to get there procedurally, you're entitled to an assessment, a taxation qua beneficiary, as beneficiary, the effect of which will be a reduction in the solicitor's bill, and in circumstances where, in essence, in that situation where it doesn't appear to be any suggestion of outside scope fees, it's simply a question of the reasonableness and the quantum, the overcharging, in circumstances where effectively that taxation would stand as the amount payable by the executor and therefore by the beneficiaries.
Has this ever been referred to since?
Well, that's a very good question to which I don't immediately know the answer. Lord, I'm afraid I'm unable to help. We can check that.
How did you find it?
I think it was one of yours, Dr. Friston found it.
I'm sorry, I shouldn't.
Yes, so it was one of
my
the
fault.
appellant's authorities, which we thought was quite interesting when we saw it.
Yeah. Well, it's only 205 years old, and if it's a very important case, as the Lord Chancellor said, it might have been referred to since.
My Lord, yes, it may well have been, and we will check that for your Lordship, and apologies for not knowing the answer to that when your Lordship asked. But the point we make is, everybody agrees that apart from the oddity that is Re Brown, if that's not too bold a term to use for it, all of the other cases that we've been referred to through Tim Martin are pure Section 38 cases. This appears to be a case dealing with the pre-act position in relation to beneficiaries who at that time didn't have the freestanding right given to them under Section 39. Section 39 came in to allow them to apply directly rather than having to use the executor's name.
I was going to ask you, given what Lord Chancellor said there, what does Section 39 do which you couldn't do before?
It gives the beneficiary a direct right to apply in their name rather than having to use the executor's name.
I see.
What, in that sense, enacts what's in this case.
Well, we would say that all Section 39 is doing is providing a procedural route for beneficiaries to do what they otherwise had to do through the executors. And that this case illustrates, and I put it no higher than this, it is illustrative of the point that there is a fundamental difference in the approach where the solicitor is aware that what they are doing is acting for a person who is acting in the situation of a trustee. And I'm sure it won't have escaped your Lordship's attention. The echo between the words used in that paragraph, a solicitor not being allowed to interpose their payment by a person in the situation of a trustee, for whom he was at the time aware that the person who paid him was no more than a trustee. The echo between those wordings and the wording we saw in Re Brown from Lord Romilly in relation to the point that the person being a trustee chooses to employ a solicitor, being well aware that there's a distinction between that and the position of a solicitor employing the same person with regard to which he is not a trustee. So it's that crucial point of a difference in approach because the solicitor knows what they're doing, is acting for somebody in that position. And I accept the point made by my Lord Justice Nugee earlier, of course, which is that it's possible there may be some situations under section 71.1 which are directly analogous. But my submission is that what we see in section 71.3 is a recognition that there is a class. And of course, the problem with defining classes is that there's always some people who might be on the fringe of that class or might, but for taxonomy, otherwise be in that class. But that's often a consequence of defining a class. What section 71.3 does is define a class which requires and is entitled to a greater degree of protection. And we say that that is consistent with what appears to have been, on an authority kindly provided by my learned friends, the common law position prior to the codification in section 39. Well, to finish off this point, before I come back to Tim Martin in relation to the second limb of the appeal, may I just deal with one proposition, which is my learned friend, although he didn't quite put it this way in his argument, and of course it wasn't his skeleton argument, but in the appellant's skeleton argument, essentially there's a sort of claim that if we are right about this, this would be unfair. And the way it's put is that because the solicitor could not be expected to obtain approval from the solicitor, and therefore the solicitors are left exposed. And just for your lordship's reference, that's paragraph 34C of the appellant's skeleton argument at page 28 of the bundle. Of course, if we're right about section 71.3, well, any question of unfairness is neither here nor there, but the question of unfairness may go to the question of whether we're right. And so just in terms of a response to that point, we have 2 points. The first is that it's important to bear in mind what is being provided for under section 71.3. This is not a case where the likely consequence of our being correct is that these solicitors are going to go unpaid. This is not an enforceability of CFA points. It's not this court recently dealt with a case on that issue. It is not that point. The consequence, if we are right about this, is no more and no less than the solicitor will be required to produce a detailed breakdown. If that breakdown is challenged by points of dispute, a judge will determine to what extent, applying any benefit of doubt in the solicitor's favour, because it's an indemnity basis assessment, to what extent those charges are fair and reasonable. That's as far as it goes. And we ask rhetorically, if it's not inappropriate to ask rhetorically, why is it in some way unfair that a solicitor who knows that they're acting in these circumstances, who knows that their payment is going to be out of the state funds, who's aware that the executor may be personally disinterested in bringing any such challenge, why is it unfair that they be limited to an indemnity basis assessment of their reasonable costs? The second point that we make in relation to this is we don't accept it's necessarily inappropriate for a solicitor, or indeed inappropriate to expect a solicitor, to take some steps, knowing that they are in that position, to seek to provide themselves with greater protection, a greater defence potentially on assessment, if they wish to do so. And in that regard, my Lord, can I just invite your attention to one further case? And then I think I'm, beyond going back to Tim Martin, I think I'm nearly finished in the authorities bundle. And that's tab 16. Which is a case called Gemma Trust, Lip Trot, a decision of this court in 2003. So this is a case where, again, so we have two executors to an estate who instruct a firm of solicitors. This is, to be clear, this is a case where the claimant was in fact somebody to whom the residuary beneficiary had assigned their interest, but for all practical purposes we can treat the claimant as the beneficiary. The beneficiary sought an account, so this is an account case of the administration of the estate. And the court then, I think it was Mr Muncaster, it was, directed that the costs of the administration of the estate be passed over to a cost judge to assess. The core point in the appeal was not any general issue of quantum or anything of that kind, but it was an issue about whether solicitors could reasonably charge both an hourly rate and a value element, or whether they were limited to only charging one. And the short answer to that was that they could, as long as the overall total was fair and reasonable. That is not the point for which I refer to this. I refer instead, and we can see it flagged up in the headnote under per curiam. It is best practice for a solicitor to obtain prior agreement as to the basis of his charges, not only from the executors, but from any residuary beneficiary who is a statutory entitled party under the 1994 order. In complicated administration, it is prudent for solicitors to provide in the terms of their retainer for interim bills. We don't need to worry about interim bills. But, my lords, if we can just come on in this, then, just to develop that point a little, at page 94, paragraph 33, this is the judgment of Lord Justice Longmore, with whom Lord Justice Peter Gibson agreed. Lord Justice Mance gave his own judgment, but agreeing with the outcome, but just giving some different
Is
reasons.
this the passage you cited in your skeleton?
My Lord, I think it is, yes. And so the court had been asked to give guidance to the profession for the future in light of the issues to which the appeal had given rise to. They found it difficult, but then at one, they identified much the best practice is for a solicitor to obtain prior agreement as to the basis of his charges, not only from the executors, but also where appropriate from any residuary beneficiary. And they note, I don't think these are in existence anymore, but at the time, there was in a Law Society booklet a working draft of such an agreement. I think in many ways the Law Society over recent years has resiled to some extent from providing pro formas of lots of these things. For example, they no longer at the moment provide a pro forma draft CFA and things of that kind. But that is the core point. So it wasn't something entirely unexpected. There'd been some guidance and help on it at least since 1995. Now, of course, that's not fully protective of the solicitor. The beneficiary might refuse their agreement. But then, of course, on an assessment, when the beneficiary challenges those, it will be the beneficiary who's put through the ringer as to why they refused their agreement and what their reasons were and whether they were behaving reasonably. The point that I simply make is, firstly, that this is, of course, consistent with our general point. Because why would it be sensible to go out and get approval from the beneficiary? The answer, we say, is because that beneficiary's approval may be relevant in the context where the beneficiary comes to challenge the costs of the solicitor.
Can I ask you, that case, the General Trust case, was concerned with something called the Solicitor's Non-Contentious Business Remuneration Order.
Lord, yes.
Has that entirely disappeared?
No, my lord, there is a new, I can't remember the date of it, somebody will help me.
2013, isn't it?
I think it's the 2013. They've been updated over time, so there is still a new Solicitor's Non-Contentious Business Order. It is referred to in the, referred to one of the cases which may be in the supplemental bundle.
I think your lordship saw it in Belsley, but I think
Yes.
it's referred to there.
I was trying to remember where Belsley was.
Yes.
Tab 26.
Yes, tab 26. So,
But I'm afraid I've completely forgotten.
well, my lord, the essence is that for non-contentious business, the test on an assessment is whether the costs are fair and reasonable and not simply whether they're reasonable.
But why does that not apply in the present case?
Well, my lord, I can't see any reason why it wouldn't.
Right. But that seems to give a separate right, looking at Gemma Trust, to residuary beneficiaries to have costs assessed.
My lord, no, we don't say it provides a separate right. All we say it does, and I don't know if this would be an issue, all we say it does is indicate the test that the costs
I
will be
see.
subjected to on the assessment.
I see.
So it provides that the cost must be no more than fair and reasonable, but it doesn't of itself provide the right to the assessment.
I see. Okay, thank you.
We can give you the updated reference to that if necessary.
This is 2009.
I'm grateful to my learned friends. So 2009. It's the sort of thing I feel as I should have known off the top of my head, and I apologise for my notes, but we will find the relevant reference and provide it to your lordships.
So, just to be sure I've got this right, your submission is that section 71(3 is what gives you the right to apply for assessment. If the appeal is dismissed and the judge's order stands, then that assessment will take place against the backdrop of the non-contentious remuneration order by reference to what is fair and reasonable.
Well, this appears to be non-contentious business, yes, so I can't see any reason why that wouldn't be the case.
But and then but it also takes place under 46.9 of the CPR.
My lord, yes, so there are the presumptions still apply as to reasonableness. Quite how that ties in with fairness, but I don't, in practice, think there's any. It's the same position as would have been arrived at in Belsner. Those presumptions would have applied in Belsner also, as to what's fair and reasonable. And in my submission, I think it will be a relatively rare case where the outcome turns on whether things are fair or whether they're reasonable. If they're presumed to have been reasonable because of an express approval, it seems to me they're highly likely to have been fair.
Thank you.
So, my lord, that was dealing with the Gemma Trust case, which, as I say, we put no higher than indicating, firstly, we take some support from it to the proposition, again, that the position is different where you have beneficiaries in circumstances where the solicitor is instructed knowing the role that they have to play and the role that their client, their true client, is playing in respect of the estate. And secondly, that solicitors are not left unprotected. Firstly, the challenge they face is no more than establishing their costs are reasonable or fair and reasonable. And secondly, they can take steps. For example, they could invite beneficiaries to agree their hourly rates, or if they won't, to set out at the start of the administration of the estate why they won't. And in circumstances where the beneficiaries either agreed them, then you would have de facto approval, which will be much more difficult to rebut than the mere de facto approval of the executive client. Or if they didn't agree them but refused to say why they wouldn't agree them, then they would probably find themselves receiving short shrift on an assessment before the cost judge in those circumstances. Your lordships will just give me a moment. Lords, I'm very grateful to my junior who explains that if further guidance is needed on how the 2009 Act, 2009 Remuneration Certificate interacts with the assessment, it's at pages 264 and 265 of your bundles, paragraph 17 and onwards of the Belsner judgment. So, my lord, we say for all of those reasons that Akin Gump doesn't apply here. And this is a binary issue. The judge was either right or wrong about this. We are either right or wrong about this. We say we are right. I will come shortly to the judgment itself, but in my submission, I'm not sure I'm going to enlighten the court a great deal by taking your lordships through the reasoning given in the judgment, because, as I say, that reasoning is either right or wrong.
Yes. So just so that we're clear, so you say Tim Martin does not apply. So it must follow from that it's your case that there is a significant difference between the rights given under section 71(1) and 71(3).
Yes. We absolutely, we don't, again, we don't shy away from that. There is a very significant difference. On the assumption that Tim Martin is correctly decided as to the scope of section 71(1), there is a very substantial difference in the effective remedies available on section 71(3).
And on your submission, in other words, that Tim Martin doesn't apply to 71(3), other than the older cases, the two of which, Brown and Hazard, there are no modern authorities at all on section 71(3).
None that I'm aware of, my lord, and it's probably wrong for me to do so, but I take some heart from the fact that both Mr. Marvin and indeed his predecessor, Dr. Friston, who writes the very impressive tome on costs, have not identified any such authorities either way.
Yeah.
So, my lord, just to draw a clear dividing line then, I am moving on from ground 1 of the appeal to ground 2 of the appeal, if we're wrong about all of that.
Just before you do that,
apologies, my lord.
You've got a very clear answer to my lord that there's a very significant difference. But I think I would be assisted by understanding what, in your submission, if you're right on ground 1, what an assessment at the instance of the residuary beneficiary is capable of doing. And in particular, can the cost judge go behind costs which have been, say, an hourly rate or number of letters written or whatever, which have been agreed by the executor?
And my lord, in my submission, the answer is yes, he is capable of doing so. Whether he does so on the facts of the case is, of course, an issue to be determined in the assessment. But
what is it he's assessing then? He's assessing fair and reasonable remuneration, regardless of whether it's been approved.
Not regardless, my lord, no.
He's still conducting a solicitor and known client assessment.
He is still conducting a solicitor and known client assessment. And
So he's still subject to 49.6.
He's still subject to 46.9.
46.9.
My lord, he's still subject to 46.9, and the presumptions continue to apply. But in our submission, those presumptions, whether a presumption applies, is first of all a matter of fact. And I've taken your lordships on the facts of this case to the fact that the cost judge was concerned as to whether those presumptions would in fact apply here.
Yes, yes, but let's assume that the solicitors got the executor not only to pay, but to approve
Lord, yes.
all their charges.
Lord, yes. In our submission, those presumptions are rebuttable, and whether they are rebutted will depend on all the circumstances. And in my submission, in the circumstances of a solicitor acting for an executor, where they know the payment is going to come out of the estate, in light, for example, of the guidance given in Gemma Trust, if the solicitor does no more than invite the solicitor to agree that and doesn't take the step of trying to get the beneficiaries to agree it or any further step, the solicitor is at risk of that presumption being rebutted and the costs being assessed despite the executor's ostensible approval.
And this is not an out of scope question.
This is not an out of scope, this is a pure assessment question.
Pure quantum question.
Lord, yes.
So the cost judge can say your hourly rate was £400, but I think £350 is a reasonable rate for this sort of work, even though the executor has expressly signed a retainer letter saying I agree to £400.
Lord, yes.
Thank you. I think I understand the length to which your submission goes.
Lord, there may be a concern as to the length to which that submission goes, but we apologies if I'm appreciating that. we come back on our part to this point that it is important to remember the circumstances that section 71(3) is intending to address. It's addressing a specific set of circumstances for reasons that we've seen averted to in a number, a small number, but nevertheless a number of the Victorian authorities. And in that circumstance, taking on board, as I say, we say the further guidance from Gemma Trust, which essentially provides a warning. Don't just rely on approval by the executor. Try and get approval from beneficiaries if you can. We say that is a warning that you cannot be surprised if in all the circumstances a judge is not satisfied that the mere approval by an executor who may have no personal interest in these matters should prevent the beneficiaries from having a challenge to the reasonableness of the solicitor's costs. My Lord, may I move on then to the question of what is we're wrong about this and what is the effect of Akin Gump, that's what happened again, apologies, Tim Martin. What is the effect of Tim Martin if the beneficiary is restricted in the same way as a third party would be restricted under section 71, subsection 1. And my Lord, I'm going to pick this up at page, if I can invite your Lordship's attention back, I hope for the last time, to the Tim Martin case behind tab 17.
Yeah.
Page 127. Paragraph 80. So here Mr. Safi was bravely trying to draw a distinction between what was properly chargeable and what was actually chargeable by the solicitor to the client, an interpretation which is not accepted of the Victorian cases. In his judgment, references to the amount properly chargeable are to be the amount which would be allowed on assessment under section 70. So that's the starting point. The third party can only challenge sums to the amount which would be allowed under the assessment under section 70, subject to one qualification, namely what I think we've been referring to as the special arrangement sums. So that's the starting point. And then at H it goes on, where a bill is assessed under section 70, not having already been agreed by the client. So this is again the important point. It's not payment that's the issue when you're looking at the assessment, it's agreement or approval. So when a bill is assessed under section 70 not having been agreed by the client, then items or parts of the amount claimed for items may well be disallowed as being excessive as against the client. That's the exercise of assessment which is available under section 70 as it is also available under section 71. So just pausing there, in principle that is open to a third party, but of course the brick wall the third party runs into is the agreement or approval.
Is what?
Is the agreement or approval. So that ability to generally challenge quantum under section 71(1) is available in principle, but runs in practice into the brick wall of approval. So if we then come over the page to paragraphs 82 and 83, so it's 82. Well, Justice Lloyd says, neither on the basis of precedent, therefore not as a matter of principle, nor as a matter of principle, does it seem to me it's open to the court on an assessment under section 70 to substitute a lower amount for a higher one on the basis that something is allowable but the rate claimed is unreasonably high, unless that substitution could have been made on an assessment under section 70. Where the client has agreed the bill and paid it, so again the agreement as well as the payment, it's not the payment, such a substitution is not possible under section 70, so that's the brick wall. In principle it's there, but the fact of agreement prevents it. And then at 83, Lord Justice Lloyd indicates the three, therefore, categories, essentially, of costs which can be dealt with under a section 71(1) assessment. I accept Mr. Safi's argument to the extent, but no further, that on an assessment under section 71, the court can strike out A, any item which relates to business for which the third party is not liable at all. So, e.g. the bankruptcy, which is outside scope of liability. So that's what I've termed the outside scope costs. Nothing to do with the estate. Mr. Marvin's point that the executor uses the fact he's having a conference with his solicitor on one particular day to have a chat with them about their conveyancing as well, or whatever it might be. B, any item which as a whole would only be allowable against the client on the basis of the advice that it would not be recoverable against the third party and therefore is to be treated as subject to a special arrangement. So that's the special arrangement category. And then he moves on to address the third category. I don't accept that either the cases or the statute allow the court to alter the amount of an item in the bill in respect of something which is properly chargeable, but where the court considers the amount claimed is excessive and unreasonable, so that a lower amount should be allowed, unless that can be done on an assessment under section 70. And he gives us an example, the judgment of then Lord Justice Lewison in the first appeal. On an assessment under section 71, the court's entitled to interfere with the hourly rate, but only to the extent it could have been interfered with at the behest of the client. And you'll note the reference there to the hourly rate that's been agreed. And so he went on to point out that in the case where the client had agreed the rate, there was very little scope for such interference. All of these references to agreement have to be read, of course, in light of the binding authority in Herbert, that agreement or approval means informed agreement or approval. So what is being identified are three categories of costs if Tim Martin applies to section 71(3), outside scope costs, special arrangement costs, and general assessment, general quantum, but only to the extent that the items challenged have not been the subject of informed approval by the client. So those are the limbs. And just to complete the circle, that's summarised by His Lordship at page 131, paragraph 95.
So that's the conclusion.
That's the conclusion. So you have what he describes as a blue pencil approach, which is knocking out total items on the grounds of A and B. And then the last sentence, just after D, he cannot either eliminate any other item or reduce it, ... unless he could have done so as between the client and solicitor. So he can eliminate other items and reduce them, but not, as we've seen, if they have been subject of informed approval by the client. So those are the three limbs. And in practice, with a lot of these cases, the third limb is one that the third party has great difficulty with. Particularly in this case, we saw at the start of this case, I took you to it, it was the underlying presumption in this case, not disputed, that the client, the bank, had approved all of the items in the bill. And therefore, obviously, the third party, assuming that was informed approval, would run into the brick wall and be left only with A and B. But it's important to note there are three limbs, three categories to Akin Gump in terms of what's recoverable. Sorry, not recoverable, what's attackable.
That rather treats approval as if it gives rise not just to a rebuttal of presumption, but concludes the matter.
Yes, although Lord Justice Lloyd, in this case, and if I think I can probably find the paragraph, but it may take me a moment, expressly concludes that the presumptions are rebuttable. So
yes, we saw that.
It's important to understand that, of course, he's addressing a case here where there's no question of the rebutting of the presumptions, and there's no doubt that the approval was properly informed approval. So it doesn't appear to be an issue that the argument is, oh well, but might still be able to rebut these. And of course, the fundamental difference in Tim Martin from the case in front of this court is Tim Martin was dealing with the outcome of an assessment. So they knew what had been done and the basis on which the costs had been disallowed. Yeah. And the court was dealing with that. Here, the very oddity of this case, which is one of my points in relation to the second limb of this appeal, all the cost judge does here is say it seems to me that there are possibilities. There are real possibilities that there may be scope for disallowances in due course, even if Tim Martin applies. We're not in a position where my learned friend can challenge Cross-Judge Brown's decision because he has disallowed X, and if you apply Tim Martin, he shouldn't have disallowed X. We're at a position where my learned friend's case has to be, there is no possibility of any material disallowance because of the effect of Tim Martin.
So do we read the final words of paragraph 95? You can't reduce quantum unless he could have done so as between client and solicitor on an assessment under section 70, as meaning, in practical terms, unless it either wasn't the subject of approval by the client, or it's one of those rare cases where, despite approval, the client could rebut the presumption.
My Lord, yes, and I would simply qualify that by saying that I think I would accept that in a straightforward solicitor-client case, rebuttal of approval may be rare. For reasons I've indicated earlier, I don't accept that's necessarily the case in an assessment under section 71.3 if Akin Gump applies, or indeed if it doesn't, if there's ostensibly approval under section 71.3. For the reasons given in the circumstances of section 71.3 assessment, the court may be keener to scrutinise both the quality of the approval and whether it suffices to eliminate any challenge to the reasonableness. So, my Lord, against that background, may I come to the court's judgment? Because whilst I indicated in our submission that in relation to ground one, this really is, and as has been accepted and granted permission to appeal by the cost judge, an important point of principle where there's simply a right and a wrong answer. And neither my learned friend nor I have taken you in any detail to the reasoning of the judge on ground one. Ground two is one which, in my respectful submission, does involve a question of the exercise of a judgment by the cost judge below. Whether, in his judgment, there were, and whether his judgment was exercised properly, there were circumstances in which reductions might be made on the assessment, even if Tim Martin applied. So, my Lord, if I can just pick it up, starting, just give me a moment. I'll just re-emphasise the point in this context at page 88, paragraph 77, which I've already taken your lordships to. So that is the point that there is a concern expressed by the cost judge, which is not the subject of an appeal, as to whether or not there is, as he puts it, agreement or approval to the sums claimed in the bill, as he puts it. Now, just pausing there, if that is right, that he can't be satisfied at the stage of ordering the assessment, whether there is approval or not, it means that there is an arguable point in the assessment as to whether the presumptions under 46.9 apply at all, or if they do, to what they apply. They may apply to either rates, but they may not apply to the detail of the bill. So if the judge's conclusion is unimpeachable on that point, and it's not sought to be impeached, then, as I submitted earlier, it cannot be said that it was not open to him to conclude that there was a reason for this assessment to go forward. And that would be, if I'm right about that, a very short answer which would dispose of ground two of the appeal. But of course I can't rely on short answers and therefore have to develop a slightly, but only slightly.
Well, you can't be sure that you can rely on short answers.
My Lord, yeah, indeed, I can't be sure.
That I do accept.
It would be bold of me to assume I could.
So we'll have that as the first point.
My Lord, thank you.
So yeah.
So if we then come on to consider what is the judge says at page 98 onwards, which is if Tim Martin does apply, how does it apply?
Yeah.
So what he addresses here, and it's important to bear in mind again the stage at which he's addressing this. He's seen the invoices, but he hasn't seen, for example, any points of dispute, any replies, or anything of that kind. He has, as my learned friend indicated, he's looked at the bill in some detail when dealing with the special circumstances point back at paragraphs 38 to 48. And he then comes back to some of the observations that he made in respect of that. So he notes, first of all, in paragraph 122, that there are costs which might, that's what he says in the middle of that paragraph, might be said to be outweigh the beneficiary's liability for costs, such as work done by solicitors dealing with their own charges or costs which are not covered by the terms of the retainer. And he's identified some costs that might possibly be caught, but he can't exclude the possibility that they may be more. So he's identified some which prima facie, he says, fall into essentially the out of scope camp. He's indicating that there may be more, and he notes, and this is important, we say in the final sentence, it may not be possible to see whether costs are outweigh the liability for the executor until a reasonable breakdown is provided, or indeed until inspection of the papers. And that is no more than the usual process of assessment.
No, sorry.
Sorry, my lord, last sentence of paragraph 122.
Thank you.
That is no more than the usual process of assessment. It is, we would say, extremely rare when what the application in front of the court is simply to decide the question of whether an assessment should be ordered or not, where the only real hurdle in ordering that assessment is special circumstances, where there is no appeal against the judge's finding that there were special circumstances. It is extremely odd in that situation then for a judge to go on, or indeed even to be invited to go on, in the absence of even knowing what points my client might want to take against the breakdown, because he's not yet seen the breakdown, for the judge to be invited to go on and reach a definitive opinion as to what the outcome of those points would be. But he does identify some points which I put in no higher than this cause him concern. My learned friend endeavoured to respond in particular to one of them, which is a concern that had been raised that there may be costs incurred prior to the formal signing of a retainer. And I don't want to disappear too much down a rabbit hole on this. But my learned friend referred in passing to the idea that, well, when you instruct a solicitor, you pay their costs. We don't have all the cases in front of us that would be needed to develop this argument, but that may be right. But usually when solicitors enter into a written retainer, they're expected to say whether that retainer operates retrospectively or merely prospectively. I just note in passing that in the supplemental bundle, the retainer letter, which is at page 24 of that bundle, refers to the agreement being the terms on which we will act for you. There's nothing in that retainer letter to say it imposes a liability for costs incurred before the retainer is entered into. I note also, just in passing, that retainer letter assumes that some regulations called the Consumer Contract Information Cancellation and Additional Charges Regulations 2013 apply. And if that's right, then under those regulations, it is, at least it could be argued and would be argued, quite difficult to enter into a retrospective retainer because you have to give the client a cancellation period before the retainer binds and notice of that cancellation period before you start any work. So I'm not seeking to say these points are good points or bad points. All I'm seeking to say, in response to Mr. Marvin's attempt to develop them, is it's by no means clear. And this comes to a point that I should take on the chin right at the outset. My client could be wrong about all of this. We could end up on an assessment, and I'm not saying that we will, but we could end up on an assessment where the judge determines that all of these charges are perfectly reasonable, or all of them have been approved and the presumption is not rebutted. All of those things could happen, and in my submission, Cost Judge Brown is not blind to the possibility of all those things potentially happening, but nor is he in a position to say that I can assume, contrary to the client's, to the interests of the applicant, that that is what will happen.
Well, by analogy with another area of procedure, the cost judge concluded that the beneficiary had a realistic prospect of success.
My lord, I acknowledge that analogy. We would say actually he didn't even need to reach that height because it was a little bit like an attempt to strike out a statement of case before you have the statement of case.
Yeah.
It's the position that we were in here.
Yeah.
But
Okay, well, I understand that distinction, but broadly, that's the territory we're in.
Lord, yes.
Underground 2.
My lord, yes. Which is why I describe this as an exercise of judgment.
Yeah.
So, my lord, it's important to note here that the judge is analysing each of the categories. So he then comes to the blue pencil test about costs of an unusual nature or amount. And he gives some indications. But we say more importantly is what he says over the page at paragraph 126. If, as he understood it to be accepted, the claimant can take any points that could have been taken by the executor, it's not easy to say that the limitation would have any substantial effect on an assessment. Just pausing there to make 2 points. Mr. Marvin's response developed today in relation to that is that when the reference is to could have been taken by the executor, apart from in relation to the final bill, there are no points that could have been taken by the executor because the executor had paid the bills more than 12 months beforehand. I'm not going to repeat, unless it would assist, the arguments I developed earlier to say why that is a bad point, because it seeks to swap the procedural question of whether an assessment should be ordered in the first place, where payment by the executor is a factor but is not the showstopper, to use my lord's expression, for the question on the assessment in due course, which is no longer about payment per se, but is about approval. But subject to that, if the judge was right in his concern that there may not have been approval, and if there is no showstopper by reference to payment, then frankly, there was the potential for all bets to be off. The point being made by the judge here, it's not clear that the limitation in that situation would have any substantial effect upon the assessment. In other words, it might be much more akin to just a straightforward solicitor-client assessment without any of these presumptions or agreements or difficulties applying. And in those circumstances, he goes on to note in that paragraph, if he's right about that, there are quite a range of possible objections that could have been taken. He appears to be less concerned about hourly rates, but essentially the deployment of the fee earners, the way they've been deployed. Now that's exactly the sort of thing where any questions of approval might be material. It might be the sort of situation where a cost judge in their huge experience looks at a bill and thinks, this seems to me to be the sort of work you'd usually expect a grade D to be doing, but it's all being done by a grade D to be doing, but it's all being done by a grade A. And one of the answers to that might be for the solicitor to say, well, we did say to the client, if you want it all done by Mr. Smith, who's the managing partner, you should appreciate that's going to cost you £450 an hour when really you should only be paying £150 an hour for that. And the client says, that's fine, I like Mr. Smith, I'm happy to pay that. That would be, in a pure solicitor-client context, approval. But there was no evidence before this judge that anything of that kind had happened. And so he was entitled to say, well, it seems to me there may be real issues here about the deployment of fee earners. I'm not satisfied at the moment, even generally, that there's approval, let alone specific approval. And so in that situation, that's an example of what he describes as the range of possible objections that might be taken if, assuming Tim Martin applies, the brick wall of section 71.1 isn't there, or is only there on hourly rates but not there on time, or whatever it might be. Which is why he reaches the conclusion, paragraph 27, he doesn't need to go into a granular level of the terms on which the assessment would take place on the assumption Tim Martin applied. At the risk of oversimplifying matters, it's not at all clear any full and fair explanation that would be required for the purposes of the presumptions exists. So he's directly addressing the point again. He's not satisfied that there is approval. Which is why he then goes on at 128 to say, whilst he has no doubt the restrictions in Tim Martin can, in many cases, severely limit the challenges, he's not satisfied that even if they applied in this case, they would prevent a meaningful assessment. So when he comes to section 71(1) principles applying to section 71(3) on the assumption that Tim Martin applies, which obviously he's found it doesn't, but on the assumption it does, he's very careful to say, I'm not here laying down any general principle. All I'm saying is, at this very early stage of this process, I cannot be satisfied that this essentially is an assessment that should be dismissed in limine. And that, we say, is a judgment which, even if other judges might have disagreed, and we say any judge who disagreed would in fact have been wrong and would have rendered an injustice to my client if they did so, but even if another judge would have disagreed, and even if I may be so bold if this court would disagree, unless it can be said that was a judgment that was not open to him, it is not impeachable on this appeal. Would your lordships bear with me for a moment? Would your lordships would just give me a moment to put my glasses on and try and decipher my learned junior's handwriting? Lord, just 2 points. Those behind me have been beavering away, although they're struggling with internet connections. So far, we haven't identified a subsequent reference to Hazard and Lane. There are none, as far as we can see, in the authorities referred to in these bundles, but that's probably no surprise, because these authorities are primarily Section 38.
It looks like the sort of thing that one might find in footnote 437 in a learned book about costs somewhere.
That's pretty well.
It's a shame we don't have Dr. Friston here, but I think it was indeed in his footnote in his learning book on costs, which is how it came to his attention and then to mine.
Well, I was going to give the credit to Miss Chu, since it's her skeleton argument and she argued it below. So whether it's in his footnote or not, I'm prepared to accept that her industry and acumen has identified the case.
Well, Lord, having had the huge benefit of the work that she and indeed Mr. Teasdale put into the authorities bund and various other matters, I would only endorse any observation in relation to her diligence and hard work.
So no reference to Hazard other than question mark footnote in
479.
in the book. Yeah, and the second point?
Lord, I think we've covered it. The only point is that obviously the focus in Akin Gump and the authorities is on Section 38, so it's perhaps not surprising it's not considered there because it would have been on point.
Well, we've done that, so
We have done that, my lord, and unless your lordships have any further questions for me,
we don't. Mr. Murray, thank you very much. Yes, Mr. Marvin, is there anything in reply? I don't know whether you want to deal with Hazard. Obviously, it's one of
Yes.
your cases, and you haven't already addressed that, so you're entitled to do that. But and obviously, any other points that you want to make, although it seems, certainly speaking for myself, as if the issues are fairly well
Yes,
defined.
there's just a couple of other things, but and I would explain why they're in reply. But on Hazard,
Yeah.
Your lordships probably anticipate I'm going to say you don't get much from it. It predates any of the relevant legislation and the presumptions, and there were no third-party rights in the Solicitors Act 1728. The facts are very odd. One trustee had approved and paid the fees without the knowledge of the other trustee, who said they were improper and excessive charges, and the court found that the beneficiaries could, on giving indemnities, use the name of the aggrieved trustee, and didn't say anything, so it had nothing about the modern legislation, and it just illustrates that before the 1843 Act, a beneficiary who wanted to do this had to be able to use the name of the trustees. It's obviously not clear that any of the points that we've argued today, or the kind of points that were argued in Tim Martin, were taken there. So I just say, your lordships, although I'm grateful to my learned junior and predecessor for finding out, if I may say, your lordship don't get anything from it. I do, and I think this is a reply point, need to deal with the suggestion that this question of payment and approval and agreement, and the suggestion, well, the judge below didn't find there was approval, and approval is required, not just payment, and that's fatal to my second ground. Just the first point of the second ground, and this is by way of repetition. I think your lordships have this point. I don't just say that the cost judge was optimistic in the way he weighed the factors and said, well, the beneficiary might get something. My point here is that when the cost judge was saying that, he was wrong in principle because he had misunderstood what Tim Martin said, even when it did apply. So there is a point of principle there. It's not just a question of his view of how realistic the points were. If he'd understood Tim Martin in my submission, he'd have realised the beneficiary couldn't have taken those points. But on informed consent, my learned friend took the court to paragraph 77 at page 89 and said, well, it isn't clear that the judge thought there was informed consent. And he said, and he took the court to some other things, and he said, well, that might indicate agreement to the final will, but perhaps not the others. The thing I need to say in reply is that was not the judge's last word on that, because he returned to this point at page 100. In fact, I ought to start at page 99, under the heading, when were the bills paid? And before your lordship say to me, that's payment, not approval, as I will show in just a minute, he meant paid and approved in the context. And what he said, so that's the heading at page 99, and then at page 130 at the bottom, he said, etc., notwithstanding these concerns for these purposes, so that's for the question of whether it was paid in the sense he's using the word, I have assumed that payment, in the sense required, did take place in respect of the last bill of August 2021 over 12 months. And the reference to in the sense required is a reference to the High Court decision in the Menzies case. That's why I say payment meant paid and approved, because he said in the sense required. And earlier in his judgment, he had mentioned the Menzies case in the High Court, and we saw that before lunch. The point about the Menzies case in the High Court is the High Court were construing paid in the statute to mean approved and paid. And so can I just go back to 3 paragraphs in Menzies in the High Court? And that's at the authorities bundle, sorry, the additional authorities bundle, tab 1, page 12. And I've just started paragraph 29 to put the argument in context. That Mr. Ralph, who was counsel for the solicitors, queried the need for informed consent to the retention of specific funds before retention could amount to payment. That's the submission that ultimately the Court of Appeal accepted, but the High Court, as we will see, rejected it. And at 31, the High Court, paragraph 31, the High Court said, in my judgment on the facts of this case, the retention of monies by the respondent did not amount to payment by the appellant for the purposes of Section 74 because there was no sufficient settlement of the account between them. And then he says he reaches that conclusion with deference to Cost Judge Rowley, but it seems that settlement account may not have been fully explored by him. And he then goes, and I won't read anything else, to basically critique the information that the solicitors had given about what the client's rights were, to say that because the client wasn't told everything he should have been told, that wasn't payment within the meaning of the Act. So when the cost judge says that that he is prepared to assume there was payment in the relevant sense, he means in the sense used in the High Court in Menzies, i.e. with informed consent. So he was prepared to assume that when he was discussing whether there was payment. And I won't go to the documents again, given the evidence before that court and this, there were bills with detailed breakdowns, there was payment with many of the bills, there were emails saying happy to pay, there was signing off on the accounts. That must surely mean that if someone wants to come along, and that must, absent evidence to the contrary, of itself be give rise to an irresistible inference that there was informed consent. That there must at least be an evidential burden on the beneficiary if he's saying there isn't informed consent to adduce something to cast doubt on all that. And just finally, on the Solicitors Act 1974 and the year-long stop, my learned friend called it procedural. I would characterise it as jurisdictional. The Solicitors Act describes and contains the jurisdiction of the High Court to assess a solicitor's bill. And so it's not a procedural point, it's a jurisdictional point. After the bill has been paid, a year after the bill has been paid, the jurisdiction goes. In my submission, that does apply to all but the last bill. And that's the point, even if it isn't necessarily fatal on the gateway to the assessment, it is a point that is an irresistible point that could be taken against the beneficiary on an assessment, and therefore it makes an assessment pointless in respect of all but the last bill. And the other point, sorry, there's just one more point. This tricky question about the relationship between approval of a bill and the presumptions in Rule 4693. The concept of consent may be much the same, but 4693 applies when you're in a detailed assessment and it gives rebuttable presumptions, and they can be rebutted. But there must, in my submission, be a point, and this is borne out by the authorities, even if it's not always at the point of payment, there must be a point at which it can be said the client has given approval to the bill, and that's final. Otherwise, this would just go on forever, and it could always be said, well, the client might be able to come back and rebut a presumption. I say that the concept in the general law of the client giving approval to a bill, it does not rely on the presumptions in that rule. It's a self-standing concept, even if the consent required may be of the test may be the same or similar. I mean, there must be a point at which a solicitor can say, my client has approved this bill, full stop. Otherwise, the thing would go on forever. And a third party could always say, well, it's only a presumption. Maybe the client could come back and say, well, I know I approved it, but I still want to take this point. And if that's right, then the whole of the Tim Martin approach, wherever it does apply, would unravel, and the exception would completely consume the underlying approach and undermine it.
I don't understand this point.
I'm sorry, Mum.
I'm sure it's my fault. I can readily understand that there must come a time when the client gives approval.
Yes.
There is such a moment. But I don't see where you go from there, because if the client manages to get an assessment up and running, he's going to lose the assessment because the court will find that he had approved and he'll pay the costs. So this is not an endless stream of blast and counterblast. The worst that can happen is you get yourselves into an assessment where you've got a defence.
Yes, up to a year after payment, in which case...
Yes, I mean, I know...
And they might, in the discretion, the court might disallow...
Something different, but I thought you were saying that although there was a moment when the client had given approval, if you leave this open for debate in some way, or for cross-firing of presumptions...
I wasn't making myself clear enough. I'm really dealing with the combination of the 2 points my learned friend made. One is he said it's always rebuttable, and the other thing he said is the bar in the Solicitors Act after a year, post-payment, is merely procedural. If you put those, and therefore it doesn't bind, that's my word, not his, it doesn't bind the beneficiary. And if you put those two things together, that the absolute long stop that the client has is merely procedural, and therefore it's merely a factor where the beneficiary is concerned. If you combine that with saying approval is always rebuttable, then for the beneficiary it can carry on forever, because the beneficiary at any point can say...
No, he can raise the issue and it will be decided. Full stop.
Sorry, my lord.
He'll raise the issue, or rather he will go for his assessment, you will raise the issue,
Well,
end of story.
Yes.
Well, that's not forever. I think all I'm having difficulty with is your suggestion that this goes rolling off into the far distant future, which it shouldn't.
No, I'm not saying these proceedings will. These will come to an end. I'm making a more general point that a beneficiary is, if you put those 2 points that my learned friend put together, then a beneficiary can always come back at any point and say, well, it's not absolutely cut and dried vis-a-vis the client, and therefore I can take the point on an assessment. That was the point I was endeavouring to make. My lords, may I just turn my back for one moment? So just one further point. I didn't reply. I need to reply on the Gemma Trust point, and I can do that very quickly. I'm grateful to be reminded of that. What it actually says is, at page 94, is that it's the basis of charging which the solicitor would be wise to put past the beneficiary. It does then go on to say it would be sensible to let the beneficiary see the bills, but it doesn't, just to be clear, it isn't saying that the beneficiary should be asked to approve all the bills. And in the context of Gemma Trust, basis of charging, it's the point my learned friend was made, it wasn't a pure hourly rates thing. There was an uplift in the solicitor's retainer for value. It's not seen so often these days. But that's all Gemma Trust, in my submission, was saying, that it would be best practice for the basis of charging to be shown to the beneficiary. In fact, and it's in the bundle, the beneficiary was told the basis. He was told the hourly rates in this case at the outset. He wasn't sent the retainer, but he was sent a letter that showed the hourly rates. But that doesn't, Gemma Trust doesn't say anything about the scope or limits of the Solicitors Act. It predated, this is an important point, it predated Tim Martin, and it wasn't really looked at. And if you look at the sequence, there seems to be this very odd thing where the Master said there was a Solicitors Act assessment, and with respect, he might have been wrong about that, and only later were the solicitors joined. So it looks like a case where the benefit of the analysis in Tim Martin, with the benefit of that analysis, what was frankly a bit of a muddle in the Gemma Trust wouldn't have arisen. And even though it was looked at as a Solicitors Act case, I would query whether that can still be the right approach after Tim Martin. Because as I say, the Masters sort of directed a Solicitors Act assessment, went to the costs office, and only later, as I read the report, were the solicitors actually joined. So it started off being a Solicitors Act assessment without a solicitor. My lords, unless there's anything else, those are my submissions.
Thank you very much. Right, well, thank you both very much. And in this case, in particular, thank you to your junior counsel and those behind you. It is right to say that before we started this morning, my lords and I were agreed about one thing in relation to this case, was that the standard of the skeleton arguments was extremely high. So thank you very much. You won't be surprised to learn we're going to reserve our judgments. You will get drafts in due course. The drafts are an opportunity for you to comment on our spelling and our grammar and any obvious factual errors, but they're obviously not an opportunity to re-argue the points. The draft will be sent out as a draft. It's subject to the usual embargo. My clerk has a list of those who will get a copy of the draft. And so therefore, as you know, nobody else save the people on the list gets a copy. Once you have responded with the typos, grammatical errors and so forth, there will then be a final version that will be handed down electronically, so there won't be any need for anybody to attend. Once you get the draft, of course, what we would hope and expect is that you're able to agree an order arising out of the draft. If you can't, then we will expect you to agree absolutely all you can and to have very short written notes on the point or points that you can't agree, and we'll decide those on paper. So either way, there won't be a further hearing. All right. Thank you all very much.
All rise available.
You will not